Good morning, everyone. Welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is the end of Chevron Deference, opportunities and threats for the healthcare industry. PYA is happy to present today's webinar on this important topic. You may submit questions during the webinar by typing a message into the questions pane of the control panel. Also, immediately following the end of the webinar, you'll be asked to complete a short survey and submit any additional questions. We will respond to questions posted after the webinar via email. We have posted in the handouts pane of the control panel a PDF copy of the slides for your reference. Also, you'll receive an email later today with a copy of the slides and a recording of the webinar. With that, I would like to introduce our presenters, Martie Ross and Kathy Reep.
Thank you, Jennifer. Since PYA started this bi-monthly webinar series, Healthcare Regulatory Roundup, back in May 2021, we focused on proposed and final agency rules, discussing their impact on healthcare providers, focusing in on compliance strategies. But since the Supreme Court's decision in Loper Bright Enterprises this summer, we've realized that we're going to end up spending some more time in the Federal Reporter, which is the compilation of federal court decisions, as we do in the Federal Register, which is where agencies publish their regulations. So today we want to take a deeper dive into how courts regulate the regulators, and how the new Loper Bright decision is likely to impact the regulated as well. Kathy and I sort of have a general two categories of regulations out there, that there are policy regulations and there are reimbursement regulations. And policy regulations talk about how you deliver care, and reimbursement regulations obviously talk about how you get paid for that care. So after sort of discussing how judicial deference works, and the changes that are brought by Loper Bright to that process, we're going to try and take a deeper dive into specifically how are we going to see changes to policy regulations and reimbursement regulations. So let's start at the beginning, kind of some background on what was, now past tense, Chevron deference, and go back to the fundamentals that federal agencies like CMS, like Office of Civil Rights, like the federal FDA, they all derive their authority from statute. There is always, should be always able to take a regulation and track it back to the statute that afforded the agency both the authority to make the regulation and then enforce that regulation. In CMS case, their authority is derived from the Social Security Act that created the Medicare and Medicaid program. So then if the regulated don't like the regulation, their option is to file a lawsuit challenging the agency's authority to have issued that regulation. And that left the courts, the federal courts that were brought these cases and controversies over these regulations, to decide how they were going to approach the review of agency action. And specifically, what level of deference, if any, would they afford the agency's interpretation of the statute on which it based its regulation. And in 1984, the Supreme Court issued a landmark decision in Chevron, where it created a rule of deference to agency action. Specifically, if you have a statute that is ambiguous, meaning there are two or more reasonable ways to read the statutory language, a court should defer to the agency's interpretation so long as it is a permissible construction. So of those two reasonable interpretations, if agency chose A, the court should uphold that interpretation, even if the court believed that B was a more appropriate interpretation of the statute. The basis for the Chevron decision was the Supreme Court's determination that it's appropriate to assume that if Congress leaves ambiguous language, it is in fact charging the agency responsible for implementing that statutory provision to interpret any ambiguous provision in the statute. That in place of requiring the court to itself determine what is the most appropriate of two reasonable interpretations, and then determining the regulatory provision. So this is a deference to the agency as it develops regulations. So since 1984, the federal district courts, Federal Court of Appeals, Supreme Court have applied Chevron deference in about 18,000 cases, challenging statutes based on what were claimed to be ambiguous statutes. And not surprisingly, the agencies have prevailed in about 90% of those cases, where, i.e., the court found that the regulation was based on a permissible construction of the statute. In comparison, in those cases where the court says the statute is unambiguous, it is clear on its face what Congress intended, in those cases, the agencies have not fared as well. That the regulated have been successful significantly more frequently than when the statute's determined to be unambiguous. So that's sort of where the game was in terms of interpretation based on statutory provisions. Now, Chevron is not the only form of judicial deference, so we want to put this in context in advance of talking about Loper Bright. When it's a question of an agency's interpretation of its own regulations, a different type of deference is applied. And when we're talking about agency's interpretation of its own regulations, think, for the State Operations Manual, which goes through and details the requirements under the conditions of participation, for example. In those cases, when a challenge is brought against the agency, courts typically apply what's referred to as Kaiser deference, or maybe there have been other names, but the most recent decision on this point is Kaiser. And that, under Kaiser deference, you defer to the agency's reasonable construction of its own ambiguous regulatory language, unless that interpretation is plainly erroneous, inconsistent with the regulation, or an afterthought rationalization. Specifically, is the agency using an interpretation of a regulation to effectively rewrite the regulation and avoid going through notice and comment provisions? So certainly not as deferential, shall we say, as Chevron, that the court is more willing to step in when the agency's reading its own regulations and regulate how that's being interpreted. And then there are other types of agency actions other than just writing rules and interpreting those rules. There are also opinion letters and enforcement action. Then there are two types of challenges we see to these other types of agency action. The first being the regulated saying, hey, wait a minute, you've issued this, you've taken this action, and it in fact is a substantive rule. You've created a substantive rule which in fact should have gone through a notice and comment period as required under 42 USC 1395 HH. Interesting little fact is the Medicare program is actually not subject to the Administrative Procedures Act, but instead there's a mini APA, as they call it, within the Social Security Act itself. So that's one way of challenging CMS's action, is that this opinion letter that you've issued is in fact a substantive rule and thus should have gone through notice and comment, and absent that administrative process, the rule's invalid. And again, that is a frequently used attack on agency action, reasonably successful as well. The other types of challenges to these other agency actions are afforded what's referred to as Skidmore deference. And really, deference is too strong a word. It's basically instructing a court to consider what the agency considered. And is the agency action have, quote, the power to persuade? Meaning, is the agency taking action based on a longstanding, consistent, or contemporaneous interpretation of the authorizing statutes? Sort of how reasonable was the agency in the particular circumstances? So Skidmore is more of a way of, is that the agency action is one of the facts and circumstances that's considered by the court, but not the definitive way of interpreting it. So Chevron, Kaiser, Skidmore, sort of the three core elements of judicial deference in review of agency action. There's more. I'm painting with a broad brush. There's lots of room between those different categories, but that's generally how courts have approached reviews of the regulators. But then came Loper Bright Enterprises, decided in late June of this year, where the court overturned Chevron deference. This has been a long time coming, as they say. There are many who have viewed Chevron sort of as the bedrock of the administrative state, that it has allowed administrative agencies to, in some cases, run wild, as opposed to the courts stepping up and playing their role as the determiners of statutory intent. And therein, what you see, that big quote, is the money quote from a multiple page opinion issued by Chief Justice Roberts, where they said it is inappropriate for a court to defer to an agency's interpretation of a statute, that in fact it is the role of the courts to determine the meaning of an ambiguous statute. That the statutes, even if they're ambiguous, and there's two reasonable interpretations, the court held that there is still a best meaning, and that it is up to the courts deploying their full interpretive toolkit to decide what the statutes mean. So go back to our example of there's an interpretation A, interpretation B. Court chooses A, and under Chevron, the courts would defer to the agency's selection of A. But now, with Chevron no longer the rule, the court would say, hey, I think B is a better interpretation, and that's the more appropriate way the statute would have given authority to the agency, and the regulation needs to be revised to be consistent with the other interpretation. Very important thing to note about the Chevron decision. It was a compromise, because at oral argument, there were concerns raised that if we overturned Chevron today, does that effectively nullify all the statutes that had previously been upheld based on Chevron deference? And the court held in the opinion that those previously decided cases, those previously upheld regulations would remain in effect. And so for about 5 days, we all took a deep breath and said, okay, it's not as bad as we thought, because we thought in many cases, the regulations have been around for years and years, and the statute of limitations would have run, and there'd be no basis for challenging regulations again. But then in early July, the court issued its opinion in the Corner Post case. And there they held the statute of limitations on challenges to a regulation begins to run at the point that the plaintiff suffers injury, as opposed to the regulation's effective date. And in the Corner Post case, the entity that brought the lawsuit wasn't even in existence at the time that the regulation had been promulgated. And so now we know that once you initially suffer an injury as a result of a regulation, that begins the statute of limitations to bring the claim. And so all those regulations we thought were safe, after the Loper Bright decision, in fact, still are open in many cases to challenge through the judicial process. So what's this mean now that we have the courts clearly prepared to insert themselves more into the rulemaking process? And part of this is you have to appreciate the judicial process. We're very familiar with how agencies promulgate regulations, but how do courts decide cases? Well, begin with district courts. Those are the trial courts, federal trial courts. There are 96 federal district courts in the United States. Some states, like my state here in Kansas, has one district court. Kathy, I think there are 5 down there in Florida, but there's a total of 96, and each district court has between 3 and 10 judges generally, both senior and anyway. Then any decision by the district court can be appealed up to the Court of Appeals, and there are 13 courts of appeals, 11 that are geographic, 2 that sit in Washington, D.C., the Federal District Court, the Federal Court of Appeals, and the DC Court of Appeals. And they hear opinions from, they hear cases from their regions. And then if a litigant is unsatisfied with the result in the Court of Appeals, they have the option of seeking review in the Supreme Court. Unlike the Court of Appeals, which have to take every appeal that come up to them, the Supreme Court has discretion and decide we'll hear this case, but not that case. So when you say the court will decide, in fact, appreciate there are a lot of courts, a lot of judges to which these cases can be brought when you want to challenge federal regulation.
Do you need to go through the process? I mean, steps?
Yeah, right. There may be administrative steps, right? Yes. Is that you have to, before you get to the court, you have to have exhausted administrative remedies. Absolutely. Right. And that's going to vary by the type of regulation that's involved. Mm-hmm. But absolutely, you have to be able to navigate the administrative process first. Absolutely. The other concept I just want to throw in here is an idea of a preliminary injunction. This is going to be more relevant to our policy-based regulations as opposed to our reimbursement regulations. But when a regulation is set to go into effect, a plaintiff can go to court, file a lawsuit challenging that regulation, but they can also seek temporary relief to what is referred to as preserve the status quo until the case is actually decided on its merit. And this is a formal motion made by the plaintiff. Sometimes it's filed with the lawsuit, sometimes it's filed soon thereafter. To receive a preliminary injunction, a plaintiff has a pretty high burden of proof. They have to show that they're going to suffer irreparable injury, which means irreparable, it means you can't compensate for the loss with dollars. In the absence of the preliminary injunction, irreparable injury. The threatened injury to the plaintiffs are going to outweigh anything that would be negative for the defendant as a result of the injunction. Prove the injunction would not be adverse to the public interest. And importantly, the plaintiff has to, in very short order, prove a substantial likelihood of success on a merit. So often there's a mini trial in deciding whether a PI is going to be issued or not. If a judge does issue a preliminary injunction, the rules of civil procedure require that they say why they're issuing it. So they go through that burden of proof and show how the plaintiff met the burden of proof. They have to describe in detail what exactly is being enjoined, either restrained or required, and then what's the scope of the injunctive relief? Who does it impact? Where does it apply? How long will it remain in effect? So that's a nature of a preliminary injunction, and then it remains in effect until the court vacates that order or there's actually a decision on the merits. So again, a little more background because it's going to get relevant as we start beginning to talk about what's been Loper Bright's immediate impact. And again, these are the impacts on policy challenges to policy-based regulations. And we're going to talk about Section 1557 and the FTC's non-compete clause, non-compete ban, because those have since June have been impacted by the decision in Loper Bright. So 1557, final rule was issued in April of this year by the Office of Civil Rights. The final rule is implementing Section 1557 of the Affordable Care Act, which prohibits discrimination in health and federal health programs, including those that receive Medicare and Medicaid reimbursement. The final rule actually is a third in the line because there was first a rule published in 16 in the Obama administration, then a version published in 20 under the Trump administration, and then the Biden administration came in 2024. So it's obviously been some back and forth on really how the scope of this provision is going to be implemented. The key provisions in the final rule include a revised definition of what it means to discriminate on the basis of sex, and that definition included gender identity as sexual discrimination based on gender identity to be sex discrimination and prohibited under the 1557. Other provisions that were relevant that are being implemented also address religious objections in providing healthcare services, extending non-discrimination to telehealth services and patient care decision support tool, IEAI. And then there's a whole set of administrative duties that were imposed on the regulated to ensure that they would comply with those anti-discrimination provisions. The rule was set to go into effect on July 5th, but then some folks ran to the courthouse to challenge it. In fact, a lot of folks ran to a lot of different courthouses to challenge 1557. The first decision we're going to talk about is Tennessee versus Becerra. This came down from the district court in Mississippi. This case was filed by attorneys general in 15 states, and they specifically filed the identity provision. On July 3, the district court issued a nationwide preliminary injunction of those provisions prohibiting discrimination based on gender identity. And you see there on the screen how very specific the judge was in which provisions would and would not be impacted by the preliminary injunction. Then in Florida, there was a case brought in the middle district of Florida. The court also issued an opinion on July 3rd, and they also imposed a preliminary injunction, but had a shorter list of regulatory provisions impacted and only purported to apply to Florida. And then also on July 3rd, it was a busy day, right before the holiday, right? Because again, the reg was set to go into effect on the 5th, so it makes sense why this happened. But the third opinion was Texas versus Becerra. This was a July 3rd injunction that applied to the rule in its entirety. Because the court found that HHS had not made a case for segregating out just the gender identity provision, that in fact the whole rule went, but it applied only again to the plaintiffs in that case, which was the state of Texas and the state of Montana. And so there's where we're at. The rule's not, the gender identity provision is not, according to these courts, not effective anywhere in the US. But in Montana and Texas, the entire rule is ineffective. And in fact, when you go to Office of Civil Rights website, they walk you through how the rule stands with these decisions. So this is, I think, a good indicator of what potentially may be in our future, is that when these policy regulations are published and there are challenges to them, there's going to be different lawsuits filed by different folks in different courts. And where do we end up in terms of compliance? Because Kathy and I actually were up at a presentation for the Montana Hospital Association earlier this week. And when we got to 1557, we said, oh yeah, you don't need to worry about that, at least for now, until there's potentially an appeal. Makes for an interesting conversation. Let's also talk about the federal trade.
But the issue and the reason that we made sure they were aware of all the components was because if it is then revised to be gender identity only, et cetera, when do they have to comply with all the various provisions in terms of a 1557 coordinator, signage, et cetera, becomes one of those issues. What kind of timeline do they have to become compliant?
It's a compliance officer's dream, isn't it, Kathy?
Absolutely. That's what they were saying. We've been waiting for this.
Yeah. Let's talk Federal Trade Commission non-compete ban. So remember back in April, the Federal Trade Commission issued a rule that declared non-compete provisions in employment arrangements to be an unfair trade practice and unenforceable. There's nuances there, but for our purposes, that's the non-compete ban. What we have in this case are dueling decisions that reach different results. So there's a July 23rd decision that came out of Pennsylvania, where the court determined that the Federal Trade Commission did in fact have the authority to promulgate and enforce this regulation. But about a month later, you have a federal district court in Texas saying, no, the Federal Trade Commission does not have the authority to do this. Where this ends up is the action by the agency. The FTC has posted on its website that there is a court order that has enjoined FTC from enforcing the rule. The FTC continues to consider an appeal and notes that the court's decision does not prevent the FTC from pursuing individual cases challenging non-competes on a case-by-case basis. So this is where it gets really interesting, I think, Kathy, is one court says, yes, you have the authority, but another court comes in and says, no, you don't. And in this case, the agency, basically made the decision to say, we'll follow the district court that said no. But why? Is it the court that says no that has the final determination of whether the regulation should be enforced or not? Because you've got a court up in Pennsylvania saying, yeah, you do have the authority to do this rule. But Texas steps in and takes a more aggressive approach, the Texas court. takes a more aggressive approach, takes a different view of FTC, and then is that injunction apply nationwide? So therein is, again, our challenge, is whether these district courts in reviewing these regulations are going to limit the effect of their preliminary injunction to just the litigants, just the state in which they have authority, or the district in which the court sits, or are they going to apply these nationwide bans or nationwide preliminary injunctions? So this is going to be really interesting.
How difficult that's going to be in terms of businesses, providers, et cetera, who cross state lines in order to be able to address.
Right.
I can't have non-compete in Pennsylvania, or I can, but I can't have it in an adjoining state. So that becomes major complexity for all employers.
Exactly. So this is one just on the future for us. There are a number of other cases that are just beginning to boil to the top, and we'll see where they go. On September 4th, the state of Texas filed a challenge to the HIPAA privacy rule to support reproductive health care privacy. We will not go into the details of this new rule, but it is intended, I hope this is a fair summary, but is intended to ensure that law enforcement is not appropriately receiving protected health information to bring an action against an individual who sought legal reproductive health care services. And the state of Texas says, no, this rule is interfering with the state's authority to enforce its own laws. And that's the state of the lawsuit right now. I do not believe a preliminary injunction has yet been filed by the state, but stay tuned. Therein is also part of our problem now. We always know where to find the Federal Register, right? federalregister.gov. We can find out what the reg is.
They email it to me every morning.
Exactly. It's so nice of them. But the Federal Reporter, which actually is not an official government publication, it's published by the West Company. It's not that simple. And you don't necessarily know. You may get the decision in the court eventually, but you don't know when lawsuits are necessarily being filed. You don't know when motions are being issued. And you sort of are very dependent on the press to sort of keep up with these different decisions. There's also a state of Texas challenge to the Public Health Services Act requirement to dispense contraception without parental consent. Texas has a law that requires parental consent in those situations. If there's been dueling litigation on this point, we'll see where this ends up with the lawsuit that was filed on July 25th. The American Home Care Association's challenge to nursing facility minimum staffing requirements. There was an initial lawsuit filed by the association on May 23rd. This one gets interesting, Kathy, because last week, one of the House committees approved legislation that would overturn the minimum staffing requirement. So another one to pay attention to. Our good friends, the Texas Medical Association, who have been litigating since 2021 on the No Surprises Act, they have indicated that they intend to raise Chevron in their ongoing litigation. And just to note that soon after Loper Bright was published, there were several letters sent to different agencies by the chairs of various House committees, asking those agencies to detail what regulations that they believe are potentially subject to being overturned by Loper Bright. So definitely Congress is ready to get into the mix as well. So from a policy standpoint, this is becoming really interesting and really does raise some challenges on how exactly as a compliance your team or as a business person, how you determine what the rules are at any given day. So with that, Kathy, I'm going to turn this over to you for a while to talk about the reimbursement challenges, which certainly don't go as quickly, shall we say, as the policy decisions.
Because from, particularly if we're talking federal programs, Medicare and like that, there's a process that we have to go through for challenging reimbursement disputes. So recognize that these do take quite a while with a normal process. But wanted to talk about some of the challenges that have occurred in the last few years and whether or not these are still viable for other providers other than those who were involved in the initial challenge. So the first one that we wanted to look at was the definition of a patient under the 340B drug pricing program. The Health Resources and Services Administration in their patient definition guidelines say that an individual is eligible as a 340B patient if the healthcare service resulting in the prescription was initiated by a 340B covered entity, okay? As opposed to an individual coming to a pharmacy of a hospital with a prescription from an outside entity, okay? And so now we're looking at how are we defining patient? So in South Carolina, the federal district court made a decision saying that the definition that has been used for HRSA by HRSA for a number of years was contrary to the dictionary. I mean, the dictionary definition of patient. So this was done in the federal district court. HRSA didn't appeal, but HRSA is only applying that dictionary definition to the one provider that brought the case, and that would be Genesis Healthcare. So the definition that HRSA has had in place for a number of years applies to everyone other than Genesis. Are other providers going to pursue this? Does this become a new issue for litigation? Broader remedy, because I think the majority of 340B providers have had to deal with this issue of what is a patient and the application of the program.
And right, the South Carolina decision was pre-Loper Bright, and given that it was focused on the definition of patient, it seemed, and whether that's ambiguous, certainly invites a review now under the new Loper Bright standard.
Absolutely. Another one, and this one is probably the most recent of the issues that we've been looking at, but been there for a while, but the most recent next decision, I believe it was around 2019, there was a change in the Medicare payment for the way they addressed the wage index. And they put in place a low wage index adjustment so that those hospitals in the lowest quartile of all wage indices across the country received a bump in their wage index. Your wage index is used to adjust your base rate to bring it up, bring it down from the average. But they increased the wage index for those hospitals in the lowest quartile, brought them up, but the way that they did this was budget neutral, and therefore the hospitals that did not get the bump in their wage index saw a reduction in their Medicare base rate. So wage index goes up for some, the base rate goes down for everyone, essentially is what they did. So a number of hospitals appealed this issue. They sued CMS based upon the 2019 redistributions, and the appeals court has ruled in favor of the providers because they have gone back and said that when you actually look at the language that is in statute related to the Medicare wage index, the statute says that the wage index is a factor that reflects the geographic area wage level differences and nothing else. Essentially, that's what the court said. But the statute says it is the geographic area's wage index based upon survey. It does go further and to address the opportunity for reclassifications, things like that, but it did not give CMS the authority to just put a totally different program in place. Courts have decided this in July. We're waiting for about another month, I guess, to find out how CMS is going to respond. They have until October 21st to appeal this decision to the Supreme Court. If you have looked, if you are like Marty and I, and you read Federal Registers for fun, then you'll see that the last couple of years, CMS lost first court. They appealed the decision into federal court, where they have again lost, but they keep saying in the rule, we're still considering appealing, and therefore they are continuing to take this adjustment to increase one group of hospitals by decreasing in others. Will CMS go to the Supreme Court between now and October 21st? Will the Supreme Court hear it? Becomes the other issue. As Marty said, they don't have to. Because of the district court's decision, and will it be sent back to the district court to determine a remedy? Will that remedy apply only to those hospitals that appealed? Will other hospitals then move forward with appealing this issue? If you think about the 340B remedy that was tied to the adjustment in the payment for 340B drugs from average sales price plus 6 to average sales price minus, that remedy was done by having those hospitals that had the lower payment for the drugs, they received a lump sum payment. Those hospitals that had their base rate increased, they wound up having a 16-year payout of those dollars.
Not just, yeah, it's everybody, right?
It's everybody.
Yeah.
Because when they increase the base, it's for everybody. So how do you take these low-wage hospitals and do similar to what you did with 340B, but rather than giving them a lump sum payment, 340B, having a reduction to their reimbursement? We've also heard that there is a possibility that Congress is going to step in on this one and actually change the language as it is applies to the Medicare wage index from that geographic area survey data to something broader than that. And if they do, then what do we wind up with? How will they define it actually? And it is appropriate to make this adjustment.
Man, budget neutrality is a pain. I mean, because you're always going to have winners and losers, and the losers go to court, and the winners, if the losers are successful, the winners become the losers, right? It's just incredibly complex. And again,
this particular case was the Bridgeport case. So if you want to take a look at it, but I will tell you that the decision was very blunt, at least out of the federal court. So we'll see what Supremes do, or if CMS even takes it to that level.
Yeah, the use of the word unambiguous means this wasn't even a Chevron case. They said the statute, we don't ever have to reach the issue of deference because the statute's unambiguous. And as we said, the agencies didn't fare as well when the courts determined the statute's unambiguous.
Another one that I guess I would say multiples related to the Medicare disproportionate share payment calculations, Medicare DISH. These have been going on for a long time, but we've got on the slide the formula for disproportionate share patient percentage. And it is, it includes your Medicare SSI days, your total Medicare days, your Medicaid days. So when we have those terms, Medicare SSI, Medicaid days, Medicare days, what do we mean? Total patient days is fairly unambiguous, but when we start looking at those various terms, so there have been challenges essentially to actions that CMS has taken on all of these various components. The definition of a Medicaid patient came about in a fairly recently decided, although this had to actually go to the Supreme Court, on the basis of an 1115. This was a Medicaid waiver, state waiver, that created an uncompensated care pool. Those dollars had to go to assist low-income patients, but they were not necessarily patients. They were not patients who were paid. They weren't a Medicaid patient, in other words, enrolled in Medicaid, but Medicaid dollars were used to compensate for their costs. So are those patients included in the Medicaid calculation of the days, or are they Medicaid, or are they not Medicaid? This was the Bethesda case out of Florida. It's now expanded to Tennessee and Texas, I think some other states. This was basically tied to a number of states that did not expand Medicaid or in Tennessee's case, just the way their program works. So recognize what is a Medicaid patient. Then we get into the question of SSI. Is this a patient? This was the Empire case. And does this get into a patient who is receiving SSI benefits or an individual who is entitled to SSI benefits? How do we define that term? And probably the most frequent issue that we have heard going back to probably about 2023 was the issue of inclusion of Medicare Advantage days in calculating Medicare days. I'm saying Medicare days, are they included? What's interesting is when this particular issue came about in 2024, it was because we were saying CMS had essentially proposed a rule that said Medicare Advantage Part C days would be included in the Medicaid fraction. And then they did not finalize that, but they did finalize without actually, without notice or comment in the rule that Medicare Advantage days would be included in Medicare days, total Medicare days. And this has been challenged. This is the Alina case. It continues to be addressed. We have more and more hospitals across the country who are essentially joining in this dispute. Final results, how will it be applied? Everyone or just those who challenged?
Okay, Kathy, for us that never took calculus, okay, and still can't add in my head, if you include the Medicare Part C days, that reduces the likelihood you'll get a dish payment, correct?
Right.
Okay, so these are hospitals that say, had you not included the Part C days, then we would have received dish.
We would have received more of the total pool.
So if these guys are successful, where do the new dish dollars come from?
The formula would not change. The issue is the retroactive. Okay, we have on the slide the retroactive change. That is because CMS did apply their change retroactively, even failing in court. They moved forward to make a retroactive inclusion of including this in the Medicare days. These are currently retroactive challenges, and to go to the fact of you owe me for prior years, essentially going back to, I believe, 2024.
This is 2024. This is 2024.
Like 2004, sorry.
Okay, like, wow, we lost 20 years there. So if we have to pay these hospitals dish money, where's it going to come from?
Going to be an interesting question.
So these remedy, because it's like the Court of Appeals will uphold, say the Court of Appeals says, yeah, right, CMS messed this up, and they'll send it back down to the federal district court to fashion a remedy. That's going to be where the game's played, right?
Oh, absolutely. Absolutely. Wow. Essentially, in the 1115 waiver case, it went back and basically the attorneys who were involved in the Bethesda case, working with CMS to come up with how are we going to deal with this? There was a transmittal that was published, I believe, either January or February of this year, essentially directing CMS how to address this issue moving forward and to make appropriate payment out to the providers. I do not, and they basically said those hospitals involved in Bethesda would be paid first. They have not, as of the last I heard, actually received the payment. So it's been 9 months almost. But again, dollars that would need to be paid out of the Medicare program. There are a lot of other issues that we keep hearing about that the concern are providers now because of the decision in Loper Bright. Are they going to move forward to challenge a number of issues? The off-campus issue of reduced payments for services provided in off-campus provider-based departments. That was done in a budget-neutral manner. There were hospitals that were maintained because you existed prior to November 2nd, 2015, versus those who were new and the adjustments with it. Is this going to be challenged? Did CMS have the authority to do this? And are they doing it appropriately? Are the Medicare Advantage plans going to be challenging a number of the things that CMS has put in place for them? The risk adjustment methodology, the audits that are being done, et cetera. Continuous state challenges to Medicaid rules, the qualification for status for certain hospitals. I know that there is actually currently a challenge to the low volume for the Medicare dependent hospitals and the LVH hospitals, low volume hospitals. Reimbursement and wages for home care, contract pharmacies under 340B, some of the programs that were put in place with the implementation of the Affordable Care Act, et cetera, et cetera, et cetera. Is this going to be challenged? So keep an eye out, because some of these issues could apply to you, and it becomes an issue that you might want to participate and appeal with.
Yeah, I mean, this may have been the most significant impact of Chevron, was that it probably had a chilling effect on plaintiffs going to court, because they could see how the agency would defend its action. And even though they could present a different interpretation of the statute, they knew that if deference was applied, they'd lose. And so with so many of these cases that have been talked about, so many challenges to regulations, now have we opened the door for more of this reimbursement rule-based litigation?
Well, and one thing to even look at is very often when we comment on a proposed rule, the comments say, based upon Chevron, they have in the past said, based upon Chevron, the agency's interpretation is incorrect. And we've had that argument. Can't have that argument anymore. We're going to have to, it's going to be kind of an interesting process. Essentially, when we move forward, the title of the slide says that the best defense may be a good offense. You need to understand the basis for any government investigation or enforcement action. What are they doing? Are they using an actual regulation to challenge what you have done? Or is it the agency's interpretation of a regulation? And is that interpretation actually consistent with the regulation itself? You're going to have to take a look at that. Martie already mentioned the impact of future enforcement actions. How confident are the agencies in defending the challenges? Or are they just going to say, you're right, and it's going to be an issue that becomes mute? The Medicare administrative contractor is, as an example, when you challenge a reimbursement issue, do they just side with the provider? Don't think so, but.
You know, our revenue integrity team, you know, that works with providers who are subject to these enforcement actions, you know, often tell us that it's not the actual regulation that the agency is relying on, but an interpretation of the regulation. Right. So yeah, the opinion letters, the subreg guidance, all of that. And what's interesting with Loper Bright, and just how these cases work their way through the system. You know, Loper Bright, some folks say it effectively elevated Skidmore to the test to be applied, right? That yes, we'll consider the agency's view if it's persuasive, but it's no longer determinative. So that lower level of Skidmore deference now is the standard to be applied by the case in reviewing these regs based on ambiguous statutes. But remember, there's that middle ground, that Kaiser deference, which is the deference to the agency in interpreting its own regulations. And that's where a lot of these cases find themselves. And court didn't overrule Kaiser. That wasn't an issue before them at the time. And Kaiser actually a relatively, you know, it was what, 2021 that the court upheld that level of deference. So it's almost strange. It's like there's greater deference to the agency in interpreting its own rules than interpreting the statute. So, but this is, I think this is going to be a hot topic, because how can it be a false claim if regulation on which the agency is holding its hat is an improper interpretation of the statute, right?
Yes.
So,
I think that was raised by an attorney with Ackerman. He said, it's going to be hard to argue that a failure to comply with an agency rule is the heart of a False Claims Act case if the agency rule isn't valid to begin with.
Well said.
You know, great quote from him. Moving on to just very quickly in terms of if you are looking at challenging a reimbursement rule from CMS, it's a little bit more involved than what was done in some of the challenges that Martie talked about with 1557 and with the non-compete issue. You're going to have to actually go through and look at the provisions, find the provisions that are causing problems, that are impacting your reimbursement amount. You're going to have to really do some work. Look at the legislative intent, the history. You might need to be going back to the congressional record in terms of the discussion behind the statute that was written. Find out who is like you. It's hard to do this sometimes on your own, but in a number of the rules that we're looking at, there were those hospitals across the country who would be negatively impacted. Can you band together in terms of sharing litigation expenses and hopefully the award from being successful? But sometimes it's best to identify others. It's something that can be done. The data is out there in terms of who else could be impacted. So it's one of those things that you really might want to do. Make sure you select good legal counsel that is really experienced in the process of Medicare reimbursement issues. If this is an issue that impacts a number of hospitals within a state, and particularly if it's one that impacts a number of hospitals positively, but does not have negative impact on others. Think about the Bethesda case with the 1115 waiver days. It impacted hospitals who were part of the uncompensated care program within Florida Medicaid. Then does the state hospital association get involved? We know under 340B, the American Hospital Association was actively engaged in that. So some of these issues need to be raised to that level. You're going to have to start with a decision from your Medicare administrative contractor, and then you're going to, if you're not happy there, you're going to go to the Provider Reimbursement and Review Board, and then you follow all the various steps. It becomes a little bit more defined. If you are going to do something not as much on a reimbursement issue, but on some of the other issues that Martie had mentioned, similar to that, more of the policy issues, then you probably picked this up from what she shared. You might want to start looking from a forum shopping perspective. It seems that the courts in Texas seem to be very provider friendly, at least so far.
And maybe on the reimbursement issues as well, too. I wouldn't rule that out.
What's all this going to do? One of the things that we need to look at is the statutory language going to be more specific moving forward? Not sure about that, because it's the idea of that, to use Martie's word, the unambiguous language versus the ambiguous language. Sometimes in order to actually pass legislation, there is a lack of specificity, and it is left to the agencies. So actually looking back at the language that is being adopted, start not just reading federal registers, but looking at draft legislation and providing comments on that as well, because that might force some more specificity into the actual statutes.
Well, and there's also the option of Congress to very specifically delegate to the agency.
Absolutely.
Absolutely. For example, like the Stark Law, it's very specific. It addresses CMS, go write the exceptions to the Stark Law. Medicare Shared Savings Program, very specific, go detail this program out. Are we going to see more of that? Because in Loper Bright, Chief Justice Roberts said, yes, there are instances where there is deference given explicitly in the statute to the agency. Our role then is to make sure they just stayed in their lane when they've written the regulation appropriately. So again, that maybe agencies may begin advocating for that in some of this legislation, that they get that level of statutory direction to write the regulations.
Longer Federal Register notices, is this what we're going to see?
Possible.
Oh, wouldn't that be fun, Martie? And this,
Sorry.
I think about this not so much from the proposed rule perspective, but the final rule in terms of the response to comments and the agencies explaining why they are moving forward with what they proposed or not. Going to be kind of interesting there. How excited are the agencies going to be about even writing some of the regulations that we really would like to have, perhaps? Are we going to have regulations related to artificial intelligence? Been a lot of press on that in the last week or so, and the need for it, but where are we going to come out? Martie, sibling rivalry?
Yeah, I just want to note that you can read the Social Security Act forwards, backwards, and sideways, and you will not find the words artificial intelligence. So I can see the agency, yeah, the concern there. The sibling rivalry and tribalism comes to the fact that we have winners and losers, particularly on these issues of reimbursement. And is that going to draw a wedge in an industry that really needs to be aligned? And then finally, just the quote, profound implications at the top of the slide is actually from an article by Fitch Rating Service talking about the financial impact of Loper Bright on the industry overall, because there's one thing investors don't like, it is uncertainty. And last week I was reading through bond documents. Yes, I know I'm a loser, but looking at what they identify as risk factors. You know, when you issue a bond, the disclosure statement has to say, here are all the risk factors, and they're all now including Loper Bright as one of the risk factors in the industry. So it will be very interesting to see what level of uncertainty we deal with in the future, and how we manage that as an industry, because we are so dependent, you know, on the availability of capital to keep expanding what we do, ensuring access to care. So this is, it's, I hate it when you can't say, well, here's what to do, but we don't know yet. It's just, again, we're going to be reading the Federal Reporter as much as we're reading the Federal Register in these days coming forward. Okay.
We're going to be going back to the statute.
Oh, wait, we have to read the, oh my gosh, I'm not sure if I can even remember how to read a statute, Kathy.
Well, and the congressional record.
Exactly. Oh, next coming up, regulatory roundups on October 9. I'm going to be joined by Karen Anderson, who's going to talk about the HIPAA rules that support reproductive privacy. I'm going to delve into the anti-discrimination requirements, so Section 1557, as well as the new regulations around Section 504 of the Rehabilitation Act. And then on October 23rd, Sarah Bowman here with PYA is going to do a 340B update. So that's what we have ahead. Of course, you can predict in November and December, we're going to be talking about the final rules, the final OPPS, the final Medicare physician fee schedule. So I hope you'll be able to join us. Otherwise, thanks for tuning in, and we'll see you soon.
Take care.
Thanks to our presenters, Martie and Kathy. Later today, you'll receive an email with their contact information and a recording of the webinar. Also, the slides and recordings for every episode of PYA's Healthcare Regulatory Roundup series are available on the Insights page of PYA's website, pyapc.com. While at our website, you may register for other PYA webinars and learn more about the full range of services offered by PYA. Please remember to stay on the line once the webinar disconnects to complete a short survey and post any questions you may have. On behalf of PYA, thank you for joining us and have a great rest of your day.